it's unfortunate that this chance, this opportunity that the Vice President is being given to present her side is practically being waived
Okay.
by the VP.
Okay, Yusek, let's dissect that into 3 issues. So the first is
Sure.
the threat versus her. The second is the threat that she made, right? And the third is what you just said. Let's do the threat versus her. In a press conference earlier today, the Vice President did give a statement when asked by reporters, no, as to why she didn't report or supposedly did not report, because she has been saying na dokumentado naman eh. All the threats against her have been documented. She even mentioned police blotters in the press con earlier. However, she did say that she doesn't trust the authorities. Now, what happens to that threat, right? So you can't investigate it because it has actually not been reported to you guys. Supposedly, you're saying you haven't found the blotters either. She claims there is a blotter. So where does that go? Let's get this out of the way because this is, I think, the shorter issue.
It would be much easier if the Vice President would simply provide us with the earlier police blotter, because we are also taking our own effort to, get from the intelligence community any alleged threat against her life. So if there is a particular person, individual, or situation that may have caused a threat on her life, it would be much easier for the NBI to proceed with a follow-up investigation if she would give details. But I do not know why she is, very uncooperative on this aspect. It's a duty of the NBI that from the very beginning I was saying we will investigate and also protect the sitting Vice President, because that is our mandate under the National Bureau of Investigation. You were also asking whether we can investigate this independent of her report. Yes, we are also taking our own effort, our own initiative, independent of her own complaint, to find out whether there are threats. And at the moment, we have not really determined any particular serious threat against the life of the Vice President as she is claiming.
Okay. The second issue is the threat that she made. Isama na rin natin doon yung third issue, which is her
Yes.
non-attendance or not showing up for the subpoena, the second subpoena. She also said in her press con earlier, no, that she does not expect fairness because from your earlier pronouncements, right after that press con that she gave, I do recall this day we also spoke to you right after that, no, Yusek, Jesse. But she said nga that there have been biased pronouncements from both the palace as well as justice officials. So I'm guessing that goes out directly to you guys. Do you believe that these are biased? Kasi umakyat din yung, she also mentioned the anti-terror law. She says it's really a plan to remove her from office.
Yeah.
Yeah.
I understand where she is coming from, but we have to do our jobs in the Department of Justice. What are we trying to establish at that point in time? We had to issue a subpoena, and that subpoena should contain a particular offense that is the subject of the investigation. So we are not making any conclusion that she is already guilty of grave threats, of the anti-terror law, or possibly sedition, or even obstruction of justice. But the subpoena is a necessary means to afford her the opportunity to explain her side on the possible charges. It has to be commenced in that manner. It is not an accusation, it is an information that is being brought forth to the Vice President so that come investigation, she would know the details of the questions that will be forthcoming. So we are not accusing her, we are not making a conclusion that she is already guilty of grave threats or of the violation of the anti-terror law. But in our public interviews, we have to inform the citizenry, those who, like people like you, so that you would be able to understand what are the possible elements of a violation of the anti-terror law. So if all of these theoretical discussions will be substantiated by actual evidence after the investigation, then due process is served. But for us to make a discussion, we always end it by saying, but nonetheless, we will give the Vice President the full opportunity to present her side, and we will also gather evidence both incriminating, possibly incriminating, or exculpating in the course of the investigation. So it is not a closed book. It is the matter of due process that we are trying to ensure. But for due process to be afforded the accused or the respondent, we have to name a particular offense so that he would be prepared to answer the potential charges. So it is unfair that the Department of Justice or law enforcement agents are already being prejudged by the Vice President. It is better for public officials to trust in the system. People are emulating her. People are looking up to her to follow the rule of law. And for her to totally disregard a subpoena, a valid subpoena, which is intended also for her own benefit and to afford her due process, is really a disservice to everyone. It's unfortunate, but we will still deal with it. And we will be able to conclude our investigation, whether or not she voluntarily cooperates or not.
Okay, Yusek, actually last November 29, the Vice President sent a letter to the NBI through her lawyers where she requested a few things. One is to provide her with questions in advance so that she can make an informed decision, and two, provide her also with other documents that initiated this investigation.
Yeah.
Yusek, did the NBI end up granting that request of the Vice President? And if yes,
Yeah.
is this something that the NBI usually does, or was it done out of courtesy?
To put it in proper perspective, a respondent is not normally entitled to anything. He is not entitled to an advance copy of questions because purposely the investigation is intended to look, also observe the demeanor of the respondent, whether the respondent is actually giving candid, accurate answers. You cannot already provide the questions ahead of time because you want to get the whole truth without it being filtered by advanced questions. So never in normal investigation will the respondent be entitled to any. So again, we are trying to proceed in this manner in a uniform way because we cannot give special treatment to anybody if we provide the advanced questions to a high-ranking official. Then we have to do it to everyone who undergoes an NBI investigation, which is not the normal process. We have to do it in the usual process, which is you come there, accompanied by your own lawyer, and when we will propound questions, and you may or may not answer. But the point is you have to respect the power of the NBI in its authority to issue a subpoena with legal compulsion to attend because that is the rule of law.
Yusek,
We have to show some, respect to legal processes, especially for public officials, because people are looking at the process, and normal people are doing it, and we cannot allow a special treatment for the vice president in this regard.
Yusek, speaking of legal processes, you said
Yes.
in the past that the Ombudsman had the authority to discipline and investigate government officials in the context of VP Sara's alleged threats. And
Yes.
sinagot po kayo ng Ombudsman ni Samuel
Yes.
Martirez. Sinabi po niya that you should shut up. Yun po ang kanyang words.
Yeah.
And sinabi niya that he does not see any valid grounds yet
Yan.
to investigate the Vice President on anti-graft and corrupt practices as well as revised penal code offenses which is related to
Okay.
this threat.
Thank you for providing me the avenue to clear that up. I made a very general statement that the ombudsman may act on the matter as well because it has broad powers to investigate high-ranking officials. I never said that the vice president can be suspended by the ombudsman. I only said he can act on it, investigate, and in fact, there is a specific provision in the law, in the ombudsman law, that the investigation can lead to a fact-finding And even the ombudsman can initiate an impeachment complaint if warranted. So it's just a general statement. And with respect to the graft law, the anti-graft law, RA 3019, definitely the ombudsman has power to investigate because public officials that would violate the anti-graft law will be investigated by the ombudsman, and eventually it can be filed with the Sandigan Bayan, and that is the
but to take
primary
over,
jurisdiction of the ombudsman.
but to take
So
over
I
the
am just
investigation.
opening up that possibility, but I am not compelling anyone to act in any way because we have our own jurisdiction. So if in their perception it is not yet ready for them to come in, it's their decision. I'm just saying I was asked a general question. Can the ombudsman also act on this? Yes, the ombudsman can act on it. So if they can investigate and they can proceed as they deem fit. That's why I was surprised why my statement was misinterpreted because I'm not asking anybody to act. I'm just saying they can possibly investigate and act on it if they deem it proper based on their own evaluation.
Pero
Okay, thank you
Yusek,
for clearing that
pero
up.
pwede mag-take over yung ombudsman. Kasi sinabi niya pwede daw siya mag-take
No,
over.
that's why I wanted to make that.
Okay.
In response to that statement, I said that the Department of Justice will stand up to proceed with the investigation because this is not a matter committed by a public official in the performance of official functions. The grave threats is a personal act. It is not in relation to her being a public official.
Right.
Only the
hold that-
matters referring to the misuse of public funds is an area that falls within the 3019 or the anti-graft law.
Yusek,
With
let's-
respect to the anti-terror law, no, the ombudsman cannot take over. And with respect to the grave threats and sedition, the DOJ has jurisdiction.
Okay, thanks for clearing that up, Yusek. Actually, that's what I wanted to talk to you about, yung threat, no? Like you mentioned, and like the Vice President insists, it is of a personal nature. I think that was her
Yes.
argument kanina, no, kung bakit hindi daw siya grave threat. So bakit daw tinatawag siya na grave threat? Right? I understood your explanation kanina that that's why you're calling her, for her to explain live
Yeah.
kung bakit hindi siya grave threat. But as it is, she
Yeah.
did not show up, and as it is, she sent a letter. Now, what I wanted to find out with certainty, Yusek, no? First of all,
Yes.
itong letter, do we separate it from the identity of an affidavit? So it's a letter, not an affidavit? Or is it both? Kind of like both? Or
As I understand, it is
Yeah.
just a letter. So it is not an affidavit.
okay.
She has the opportunity if she wants to present a sworn statement, and that would be most appreciated by the NBI because we want to hear her side. We don't want to limit our evaluation on the basis of just the investigators coming from the NBI and other law enforcement agents to gather all the facts. The facts or the narration coming from the VP is something that we need so that we can put in proper perspective her statements. But otherwise, we will still proceed with the investigation and make our own evaluation based on the literal translation and understanding of the utterances of the Vice President. Grave threats is so easy to prove because it doesn't matter whether you are bluffing or not. The fact is, if you give a threat to an individual of harm to him, his property, or the family, that already consummates the crime of grave threat. The anti-terror law also is being looked at because it is a very broad law where a threat to the life of a public official, when it is being done to sow fear or intimidation, can already be punishable even if it is not actually done. The mere proposal to commit those acts of threats or a conspiracy to do these acts of terror, even if the actual terrorism is not done, is already punishable.
Okay.
Because that is how broad and strong this law is. Because it is intended to protect the entire population, the citizenry, the society. Terrorism can exterminate a whole community. That is why the government should have the ability to prevent such large-scale or dangerous occurrences that will threaten lives of communities. That is what is being intended. So even a mere proposal is already punishable. That is why we're saying with enough evidence based on due process, we are looking at this as a possible charge. But we are not precluded from, not filing or filing, but we will base it all on the evidence because we have changed the rules in the Department of Justice now.
Yes.
It is no longer probable cause, the possession of evidence that can engender a probability of guilt. No, our higher threshold of evidence now is prima facie evidence with reasonable certainty of conviction. So it is not a flimsy evidence, it's not a slight amount of evidence. It is convincing evidence that will warrant a conviction in court. That is the kind of evidence that we need to gather before we file a case in court.
Yusek,
And
what
we
happens
are
now?
doing that.
Right. Yusek, what happens now? Pretty much we're cut and dried with today. 2 subpoenas snubbed. What happens now? Does the NBI proceed to investigate, then refer it to you guys pag may charges na with all the prima facie evidence? What are the
Yeah.
difference? How many scenarios are we looking at here?
Yeah. There is a principle in constitutional law that you have the right to remain silent, you have the right against self-incrimination. But the government and the law enforcement agents are not helpless in gathering evidence. We can apply to the courts for a cyber warrant, a warrant for more information. We can subpoena more people. We can investigate previous acts committed in the past. There are many things in the past that are covered by media. The previous utterances of the Vice President are all evidence that can be used in this investigation.
Okay.
We have to put the entire context. If it is a sedition matter, it is not an isolated snapshot. It has to be a public and tumultuous act that affects security. So it is not just the statement given during the press conference where the Vice President made threats on the life of the President, the First Lady, and the Speaker of the House. There are so many other statements that you can take in to put the correct context of that last statement.
Yusek,
So
bilang panghuli.
that taken
Oo.
together will be the evidence in chief.
Yusek, bilang panghuli, kasi naubusan na po tayo ng oras,
Sorry, yeah.
The one threatened here is the president. What if he does not want anybody to pursue this anymore? Because he says this is a waste of time. Is there no case?
As I understand, the president was referring to the impeachment process as
Just
a waste of
hypothetically.
time.
But what if?
Hypothetically.
But what if ayaw na po niyang i-pursue yan?
In every criminal offense, there is a public interest involved because the criminal laws actually protect the public, not just the private offended party. So there are 3 possible private offended parties: the President, the First Lady, and the Speaker of the House. They can be complainants. They can, decline to participate, and that would, not proceed to engender sufficient evidence for a conviction. And that is probably a reason where the courts can acquit the accused if they will not participate in the trial itself. But
All right.
the job of the Department of Justice now, first, is to determine whether a charge should be filed in court. Whether or not they will participate in the eventual court proceedings as witnesses would be a different matter. So it is possible that the court will not find the accused guilty because there is not sufficient evidence, and that is when desistance is resorted to, affidavit of desistance, so that the court will have a basis to dismiss the charges.